This is the Scuba Educational Alliance Ocean Podcast, Episode 1. The Scuba Educational Alliance Ocean Podcast is a bi-weekly podcast dedicated to the world of scuba diving, ocean health, sustainability, and fostering a new generation of ocean stewards through diving education. Well, hello everyone. I'm Jeff Centropino, founder and president of the Scuba Educational Alliance of Connecticut, and thank you so very much for tuning in to this first episode of my new podcast. The Scuba Educational Alliance Ocean Podcast is a bi-weekly show dedicated to the world of scuba diving, ocean health, sustainability, and fostering a new generation of ocean stewards through diving education. Now, I am hoping to build on the legacy of Scuba Shack Radio, a podcast supporting the dive shop. I wrapped up Scuba Shack Radio in July. The timing was right, as we did in fact finalize the sale of Scuba Shack at the end of July. Since then, Donna and I have been working on the transition, along with having a fantastic week out in the Sea of Cortez on board the Rocio Del Mar. And while the transition is finished, that doesn't mean I'm slowing down. Just means I have more time to dedicate to Scuba Educational Alliance of Connecticut, a personal passion, as well as my continued work with the Diving Equipment and Marketing Association, Scuba Diving Industry Magazine, the Level Up podcast from the magazine, and helping the Boston Sea Rovers with their next show. Now, the format for the Scuba Educational Alliance Ocean Podcast will be similar to Scuba Shack Radio. I'm planning to have a news and information update. This segment will be called Sea State. There's always something happening. I will then have a featured segment where I will go into a little more detail on a specific topic related to diving or the ocean environment. I would also like to do more interviews. We'll see how that goes. So for this first show, my featured segment is going to be on a recent Supreme Court decision that you might have heard of, and that's called Chevron Deference. This could have very long-term implications for the environment. But up first is Sea State, News and Information Update. This is Sea State here on the Scuba Educational Alliance Ocean Podcast for September 19th, 2024. First up today are a couple of good news stories. There was a short article on Deeper Blue written by John Liang. The headline reads, Environmental Groups Laud U.S. Court's Decision on Protecting Imperiled Marine Species from the Effects of Offshore Drilling. Now, the U.S. District Court in Maryland struck down the 2020 biological opinion of the National Marine Fisheries Service under the Endangered Species Act. The lawsuit was brought by a nonprofit organization, Earth Justice, who challenged the opinion on behalf of the Sierra Club and several other organizations. The group argued the biological opinion did not adequately evaluate the potential for future oil spills in the Gulf of Mexico and did not represent sufficient safeguards for imperiled whales, sea turtles, and other endangered and threatened marine species from industrial offshore drilling operations. Earth Justice has an interesting tagline, because the earth needs a good lawyer. They have 15 offices, 200 lawyers, and 620 active legal cases. Interesting timing on this one, as we'll hear in my future segment. The second bit of good news comes from the Maryland Matters website, which carried a Chesapeake Bay Journal article written by Carl Blankenship. This ran back in August. The headline, Chesapeake's underwater grasses rebound for the third year, and everybody's cheering the expansion of eelgrass in the lower bay. Now, the article indicates that the grasses greatly increased in moderately saline areas and remained stable in low saline areas. There has been a 7% increase since 2022. Why is this important? The eelgrass provides an important refuge for juvenile blue crabs and fish, as well as provides food for waterfowl. Also, the grasses help stabilize sediment and provide a buffer against wave action. Now, they are attributing the increase to the fact that the water is cleaner due to the controls that they put in place on agriculture, plus the warmer winters accelerate the growing season. Well, I guess warmer temperatures are helping here, but there is a caution that warmer summers could have a negative impact. But we'll take this bit of good news for now. On the flip side of good news is some bad news out of Florida. WTSP-TV out of Tampa reported that according to the environmental officials, last year's marine heat wave, and it was hot, caused a severe decline of elkhorn coral. You might recall that the water temperatures in Florida last year were in excess of 90 degrees Fahrenheit, and that caused the worst bleaching event ever. Just how severe was the bleaching? Well, according to NOAA, before the heat wave, there were 160 elkhorn coral genotypes. After the event, only 37 remain. That's a 77% loss of genetic diversity, which is crucial for coral growth. Just for reference, bleaching can start when the water temperature is 87 degrees. Last year was about 93 degrees. There are, however, 180 genotypes currently in coral nurseries and gene banks, but unless we do more to conserve energy and lower water temperatures, we're most likely going to see this continue to happen. Also, remember to use those reef-safe sunscreens. Every little bit helps. Each year, the Diving Equipment and Marketing Association recognizes members companies that use their recreational diving business and positions in the community to make a difference either globally or locally. These awards are known as the Diving Community Champions Award. There are 3 awards given: platinum, gold, and silver. Wonder what happened to just gold, silver, and bronze. But anyway, DEMA recently announced the 3 winners: Dive Heart Foundation, Jack's Dive Locker, and the Professional Scuba Inspectors Incorporated. These awards will be presented during the annual members meeting and update and meeting in Las Vegas on November 20th. I'll definitely be there to see the winners. Now, for those who have listened to Scuba Shack Radio, you'll know that I have talked about REEF. That's the Reef Environmental Educational Foundation and their annual Lionfish Derby. Well, here's the update on the latest derby, their 15th annual Lionfish Derby and Festival. There were 14 teams that participated, and they collected 1,527 lionfish over the 2-day period. That was August 16th and 17th. Then, on August 18th, they had the weigh-in, scoring, cookout, and awards. $6,000 was awarded to the teams, and they had the teams with the most, the largest, and the smallest. One team captured 321 lionfish. The largest measured over 16 inches, while the smallest was only about 3 inches long. Now, since 2010, Reef indicates that more than 70,000 lionfish have been removed from the Florida reefs during their derbies. That's a big number. So next year, the 16th annual event runs a little later, September 4th to the 7th. So if you happen to be in Key Largo next year this time, you might want to check it out. Last month, I spent a week in the Cia Cortez on board the Rocio Del Mar, one of the Mexico Liveaboard's 2 boats. Well, while we were on the boat, we heard that they were building a new boat. Well, Mexico Liveaboards formally announced this new boat, the Kino Del Mar. It's going to replace their original boat, Kino El Guardian. The new Kino is set to launch in July 2025. It will be a little bit bigger than the Rocio, and it measures 118 feet with a 26-foot beam. It will feature a brand new steel hull construction and accommodate up to 20 divers in 10 private staterooms with their own bath. 8 staterooms will be on the upper level and 2 staterooms on the lower. The main deck houses the large salon, dining room, and kitchen. Congratulations to Dora on this accomplishment. I will be looking forward to catching up with her in November and see how it's going. They run a great operation. And finally, one of the challenges the scuba diving industry faces is breaking down the barriers to getting younger divers in the sport. The Women Divers Hall of Fame continues to work on breaking down the financial barriers with their annual scholarships and grants, and the applications for the 2025 program is now open. It opened on September 1st, 2024, and will close on October 31st, 2024. Happy Halloween. Now, this is the 25th anniversary of the Women Divers Hall of Fame, and to celebrate, they are offering 25 $1,000 basic and/or advanced training grants for 2025. Looks like this is in addition to their other scholarships and awards. In 2024, they provided 47 grants and scholarships totaling $57,000, and since they started, there have been 471 individual awards to the tune of over $500,000. Now, this is a great way to break down one of the barriers for a new generation of divers. We're going to continue to do this with the Scuba Educational Alliance of Connecticut as well. Well, that wraps up this first installment of Sea State here on the Scuba Educational Alliance Ocean Podcast. Over the past several years, it's safe to say that the Supreme Court of the United States has been in the spotlight, a very big spotlight for many different reasons. The court has taken many different cases that have been very controversial. The decisions that have come down have had many individuals cheering, while others are disturbed and upset with the direction. We all have our opinions. Well, there was a decision rendered back in June that I think is worth noting and why it might have some very big impacts on the environment in the future. The decision reverses what is known as Chevron Deference, and we'll get into a little more detail about that in a minute. The decision is in the case of Loper Bright Enterprises versus Raimondo. The vote was 6-3, and the decision reversed the 40-year precedent. Now, instead of allowing experts in the federal agencies the ability to interpret ambiguous language in the laws pertaining to their work, federal judges now have the power to decide what these laws mean. Is this legislating or policy making from the bench? I don't know if I can answer that, but now, does the Environmental Protection Agency have the ability to make regulations? Not sure how this is all going to play out. Let's take a look back at how Chevron Deference came to be. The case that created the Chevron Deference precedent was Chevron USA v. Natural Resources Defense Council, Inc., or NRDC. That was in 1984. And here's the twist. Back then, the EPA was headed by Ann Gorsuch, yes, the mother of current Supreme Court Justice Neil Gorsuch. Under the Reagan administration, the EPA redefined the meaning of the source of pollution. It broadened the meaning to be an entire plant or operation, not just an addition to the plant. That meant that there could be little checks on the environmental impacts when a company wanted to expand its operation. So the whole case centered around one word, source. The NRDC challenged the EPA and won in federal court, but on appeal to the Supreme Court, they ruled that courts should defer to the EPA and other independent regulatory agencies when there is ambiguity like this. In this case, the agency was relaxing regulations. Interesting. For a little history lesson, the 6 justices who voted for Chevron Deference were Chief Justice Warren Burger, along with Associate Justices John P. Stevens, William Brennan, Byron White, Harry Blackmun, and Lewis Powell. Justices Thurgood Marshall, William Rehnquist, and Sandra Day O'Connor did not take part in the decision. Okay, so since 1984, Chevron Deference has been one of the most cited opinions in litigation against federal agencies. Now, in 2020, Loper Bright Enterprises, that's a New Jersey-based family-owned herring fishing company, challenged the National Marine Fisheries Service's ruling calling for individual companies to pay for government-certified monitors that are required under the Magnum-Stevens Fisheries Conservation and Management Act, or MSA, of 1976. That's a mouthful, and I keep thinking about MSA as Master Services Agreement. So Loper Bright and others filed a case at the D.C. Circuit Court, and the court agreed that the National Marine Fisheries Service could do this based on Chevron Deference precedent. Now, I can see their point on making you pay for federal monitors. The case was then appealed to the Supreme Court, and the two questions before the court were: 1. Does the Magnum-Stevenson Act authorize the National Marine Fisheries Service to promulgate a rule that would require industry to pay for at-sea monitoring programs? Okay, that seems like something to resolve. But question 2 said, should the court overrule Chevron v. Natural Resources Defense Council, or at least clarify whether statutory silence on controversial powers creates an ambiguity requiring deference to the agency? Oh boy, was this a setup. There are some who say that the case was really brought before the Supreme Court because many felt Chevron deference was wrong. Perhaps Chevron deference was a problem. You see, federal agencies take on direction based on different administrations. So sometimes we may seek to tighten up environmental protections, while others might look to loosen regulations. That was the case with Ann Gorsuch and the EPA in 1984. An interesting twist here is that Justice Gorsuch was dead set against Chevron deference, and he wrote, "Today the court places a tombstone on Chevron no one can miss. In doing so, the court returns judges to interpretive rule that have guided federal courts since the nation's founding." So, where does this leave us, especially when laws are being written regarding protection of the environment? If Congress doesn't specifically provide all the details in the legislation, they can delegate the authority to the regulatory agency. Is this a loophole? Not really, but I also heard and read about some who want to bring this to the Supreme Court, as well as challenge that Congress cannot delegate authority at all. If that were to happen, well, things would be even more chaotic than they are post-Loper Bright. Right now, I think that many who are advocates for ocean health and sustainability, protecting the environment, and combating climate change believe this decision will be problematic by taking the policy away from the experts in the agencies. But then again, it cuts both ways. I'm still wrestling with the decision. We also know that judges are not perfect, appointed by the party in charge, and some have very strong opinions. Will this open up a flood of judge shopping when it comes to environmental policy? And then there are the appeals both ways. And while the appeals go on, the oceans and the environment and the planet could lose. So, if you haven't heard about Chevron deference before, I hope I gave you a little bit more insight. I'm still trying to process the decision. Well, it's time to wrap up this first episode of the Scuba Educational Alliance Ocean Podcast. Thanks for tuning in, and you can keep up to date with the podcast every 2 weeks by subscribing from your favorite podcast service. We're on Apple, Spotify, Amazon Music, Android, and many others. We're out there on all of them. So until next time, take care and take care of the oceans. This has been the Scuba Educational Alliance Ocean Podcast, a show dedicated to the world of scuba diving, ocean health, sustainability, and fostering a new generation of ocean stewards through diving education. Talk to you again real soon.